First article is about Motor Vehicles Amendment Bill 2017. The issue is that this particular bill has been passed by the Lok Sabha fine in 2017 and it's now pending in Rajya Sabha. If it is passed by the Rajya Sabha, then it will be first of its kind to extensively reform existing legislation on road safety. Right now we are having means regarding the road safety and all, we are having this Motor Vehicles Act 1988. There are certain lacunas, there are certain loopholes within this act, because of which the road accidents in India are they are increasing, and they are increasing exponentially. Fine, I'll tell you the data later in this article. So the thing is that if it is passed, then definitely it will rectify several systemic issues in this Motor Vehicle Act 1988. Now, the first thing this particular article is saying that this new bill, it is going to be digital. Fine. The thing is that what they mean by digital is that they're creating a kind of it's like central, it's a repository, fine, digital system where the information regarding the licenses of drivers throughout India will be fed in. Fine. So it will be easier. Why it will be easier? Because if suppose there is a driver and he has done something, I mean he is involved in some sort of road accident, then it will be easier for the police and the authorities to check out that okay fine, this is the driver. They can just easily check within the central database which they are having to. So the essence is that they're trying to basically create a central database system. Fine. So definitely it will not only save the time of the authorities and all, but it is somehow creating a kind of deterrence on the drivers, that yes, the information is there in the central database. Because at present what happens is that all this procedure, it's entirely manual. Fine. The procedure is entirely manual, and number of license is issued per year. I mean crores of licenses are issued per year. So definitely when so what happens is that in such situation a single person is having multiple licenses. Fine. See, multiple licenses are held by 1% for different states, and low penalties. And right now the thing is that low penalties are there for the licensing offenses. Means whatever the offenses related to licenses are, very low penalties are there. So definitely they can easily get away by doing any road accident or any sort of serious injury in a road crash and all sorts of things. So the first thing is this. Now second thing is this, that not only this licensing procedure is going to be digitized, but the bill also introduces to digitize the entire monitoring and enforcement of traffic laws. Means the entire monitoring and enforcement mechanism of the traffic law, laws, fine, it will be digitized. See, this type of electronic monitoring and enforcement is already in force in Kerala, and it has been quite effective. So, what we are trying to do is to replicate this kind of system in entire India. So these two steps are in the direction of digitization. The first is this kind of central database regarding licensing, and second is this electronic monitoring and enforcement mechanism. Second, this bill will focus is the children in focus. See, in 2000 alone, 7% of road crash deaths, they were involved, they involved children, and that too below 18 years. Fine. So WTO asserts that there should be some sort of child restraint systems. What sort of systems they can be? See, the bill proposes that it will be when this bill becomes act, then it will be mandatory that everyone who is riding the bike, or who is just sitting behind the driver, or I mean anyone, so fine, even the children below the 4 years of age, they need to have a headgear, or one can say helmet. Fine. And similarly, the use of safety belts and child restraint for those under 14 years. Okay, and there is a fine of 1000 also for the driver and the guardian. So this is with respect to the children. Next is the next reform in this bill is regarding penalties. Actually, the penalties are quite less. Right, in the present Motor Vehicle Act 1988, the penalties are very minimal. So definitely, when penalties are minimal, so they can easily, escape these things just by giving the bribe, just by giving the minimal amount of penalties, not the bribe. Okay, so however, in many cases bribes are being used anyways. This is not a part of the article. So the penalties are minimal, so definitely people can get away with it just by paying it. And so what the government is trying to do, they are going to revise these penalties. For example, for drunk driving, the penalty has increased from 10,000 to 15,000. Fine. So, and similarly for speeding and all these things. Moreover, writer is saying that India is a signatory to Brasilia Declaration on Road Safety, and as a signatory to this declaration, India has committed to reduce its road crash fatalities and serious injuries by 50%, and that too by 2020. 2 years are left. So definitely we need to pass this act in Rajya Sabha, and we need to make this act effective as soon as possible, because India has to achieve this particular target. This was the essence of this particular article. Second article is about the Malmuth Committee report on criminal law revamping. Fine. This Malmuth Committee is focusing on this particular thing. Now, what the article is saying, that okay, a center should definitely revisit the 2003 report of the Justice V.S. Malmuth Committee on reforming the criminal justice system, but definitely caution must be taken. The writer is saying, but this entire revamping should be examined through the prism of civil rights. What it means, that in means, okay, when you are this revamping and reforming this, you're trying to come up with the recommendations of Malmuth Committee, then care must be taken that in order to reform the criminal justice system, civil rights of the people are not violated. So we need to re-examine all these things through the prism of civil rights. Fine. Now, there are certain controversial recommendations within this Malmuth Committee reports. For example, it makes confession to a senior police officer admissible as evidence. Second is, it dilutes the standard of proof required for criminal conviction. So these are certain controversial recommendations. Obviously, care must be taken whether to whether to implement these or not. Now, but the thing is that it also had certain valuable suggestions to revamp the administration of criminal law from investigation to sentencing. Fine. So the thing is that this Malmuth Committee report is trying to focus on the entire spectrum of criminal justice administration, right from the right from this investigation to the trial, and finally to the sentencing of some sort of punishment by the judiciary. So the entire spectrum is covered within this, and many valuable suggestions have been given by this committee. And up till now, it has made 158 recommendations, and many of them basically now have become a law. Okay. For example, permitting videography of statements has been implemented. Then definition of rape has been expanded, and new offenses against women have been included. For example, the definition of sexual harassment is also increased. Now the some sort of constant stare or abuse of abusive words is also considered as under sexual harassment. So these has been the entire range has been extended. And but the thing is that obviously we have not been successful in providing this witness protection. It has not been realized, but victim compensation is now a part of the law. Fine. Apart from that, this article is saying that center must take care while considering these two things. Where are these? Yeah, the first is that the first thing which the center must ignore according to this article is that making confessions to high ranking officers admissible. Oh, where this is going, sorry, making confessions to high ranking officers admissible. Means if suppose any confession is given to high rank officer, then it will be admissible in the court as evidence, as proof. And the thing is increasing the period of police custody from 15 to 30 days. So the article is saying that these provisions, they should only be in anti-terrorism laws. Fine, they should not be in normal or general criminal laws. So definitely care must be taken, and as I said earlier at the top, that we need to revamp this entire criminal administration system through the prism of civil laws. Fine. Now, next, as I have told earlier, that Malmuth committee report suggests us there should be dilution of standard of proof. Fine. And now this committee is suggesting that, not now, but obviously this committee has suggested that a clear and convincing standard is enough. That means if the court is convinced that something is true, then it's okay. That will be considered as evidence. Fine. So such measures could have adverse implications on the suspects. Fine. And it may be a chance that many of the innocent lives, they may suffer because of it. So the thing is that this entire criminal justice administration is in, dire need of reform and revamping. Fine. And the thing is that this why this is in the dire need of reform. So Madhav Menon committee, it drafted a draft national policy on criminal justice system, and it noted that why people consider that our criminal justice system is not enough and certain reforms are required in it, because there is popular dissatisfaction from the low rate of conviction. Fine, laws are there, but low rate of conviction, apparent role of money, muscle power, and influence in the outcome of cases. We can see that because of money, many a times people who actually committed the crime, they are free out of the court. Fine. Then justice is not only delayed here, but justice is denied at the last. And lack of protection to witnesses, this is really very serious, because of which justice is not actually delivered. And inadequate attention to crime victims. Many a times what happens that police, it files a case and everything is done, but what happens is that the victim is not provided protection, and because of which because of which in many cases, especially those who are poor, fine, they think that it's not good for them to file FIR even, because either their lives will be in danger, or use of money and muscle power will be there. So this is the case. And then there is nexus of politicians and this entire enforcement agencies are also having this kind of nexus. So the essence of the article is that, okay, we need to revamp this law, but the thing is that we need not to undermine the principle on which the justice system is founded. Means that the basic foundation of justice system should not be violated in revamping this criminal justice administration or criminal justice system. This article is talking about a risky recovery. See, IMF has given its World Economic Outlook report and said that global economy is definitely moving in a very good direction, and it's going to be its best. It's going to have its best growth rate in 7 years in 2018, following a pickup and since mid 2016. That means the global economy has basically had a pickup in mid 2016, and it's going to have the best growth in 2018 after around 7 years. And for India, it predicted that India is projected to grow at 7.4% during the financial year 2019, and the following year, that means in 2020, the pace will be more, that will be around 7.8%. And if means these predictions, they come out to be true, then India will be the fastest growing major economy next year, because China's growth is expected to be slow. Fine. Now the thing is that obviously economy is growing and India's growth is also expected to be higher, but IMF is not oblivious to the threats that could derail the broad based economic recovery. That means, with this prediction of growth, IMF is also aware of the threats involved in this recovery. Fine. So, sorry. It warned about the troubling rise in debt levels across countries, including US, which could pose a huge risk to financial stability and drag down economic growth. See, whatever this growth is, fine, it's somewhat demand driven growth. Actually, many of the countries, including US, they are in huge debt levels because their corporates, they are having debts from the foreign sources or from the government, and because of those debts, I mean, they are having finances, then they are producing more, there is demand for the people. So this way the growth is, growth is there and growth is expected to be there. But the thing is that this all growth, the foundation for this is this debt. So it should be in a sustainable level. IMF is, I mean, this threatening this thing. Now, we all know that since 2008 financial crisis, global economy has been propped up only by easy money policies. Fine. So the thing is that whatever the growth since 2018, the global economy, and in fact major economies, I should say, they had, it's because of the easy monetary policy. And as we know that in easy monetary policy, what we are having, I mean, the interest rates, they will be lowered by the central bank. So the banks will be having, the banks will lend more to the corporates, and corporates, they will invest more. They will, if suppose a company is having more money, it will set up several different branches, and so employment will be created, demand will be created. But there is a limit to this easing out of monetary policy, because we know that when there will be huge demand, and because of this, too easy monetary policy, in longer run inflation will be there, more and more inflation will be there, because the products will be more in the market because of huge production, and demand will not be there, fine, in the longer run, as well as the value of those commodities will increase. So this is the thing, that easy money policies in short run, they're good for the economy, but not in long run. So IMF is suggesting that in fact, the absence of substantial structural reforms to complement central bank stimulus measures have been another feature of this present global economic recovery. It means the article is saying that although with the easy monetary policy, economies are growing fast, but one distinct feature is also there, and that is that these countries are not, having structural reforms within that. Okay, so the thing is that such a recovery, which is predicted by IMF, it comes with an inherent risk of being derailed whenever easy money monetary policy conditions that fuel it cease to exist, because these conditions, they are not going to be, for long run. So some sort of structural reforms are required in the economy. IMF is suggesting this. See, IMF is right to urge countries to make use of the current rosy conditions to enact useful structural reforms. So, IMF is saying that, okay, you're right now having easy monetary policies, but along with that, certain sort of structural reforms are required, so that the demand in the economy is not monetary policy driven, but inherent driven. Fine. So, the essence is that along with monetary policy, certain sorts of structural reforms are required, so that whatever the growth the IMF has predicted, it may last long. Okay, this article is talking about the debate regarding governors' discretion, fine, the limits to it in certain cases. For example, the article is saying that Kerala governor, fine, he omits certain parts of the speech which was prepared by the government of the day in his address to the assembly, fine. And this article is saying that it's not a new, it's not a new thing that we have witnessed. Earlier also, many a times governors have done this thing. They have skipped certain portions of the speech given to them by the council of ministers of the state assembly. Fine. For example, the article is giving examples of Tirupura governor who skipped certain portions of the address containing critical remarks drafted by the left front government against the center. So this Tripura governor, he skipped certain parts which was given as a part of the speech to him by the left government, and it was those parts were basically criticizing the central government. Similarly, in many cases this has actually happened. Now the thing is that this omission which is done by the governor, does it violate any constitutional convention? Because we say that governor has to act by the aid and advice of the council of ministers. Fine. Like president has to act in the aid and advice of council of ministers, similarly the governor has to in the state. Now the thing is that in Samsher Singh versus State of Punjab, Supreme Court, it quoted the opinion of the first Attorney General that the president, as I said earlier, the president is guided by the aid and advice of the cabinet, covered every function. Fine. Whether it relates to addressing the House or returning a bill for reconsideration or assenting or withholding assent. Everything. So in the next paragraphs in this article, they are basically quoting certain thoughts of a book which is given in it's a book, fine, written by Chatterjee. So we are not going so deep into that because we are just going to the essence of this article. And the essence is saying that, see, in the example of this Tirupura governor, he skipped certain portions which was basically against the center. Fine. In the similar case, there was also one of the case, I'm not getting it, I don't know where it is, it may be somewhere else. So the writer is saying that if there are certain portions in the speech which are against the center or which are against the judiciary or judicial judgments, so in that case the governor, if governor, it omits certain sections from the speech, then it should not be considered unconstitutional or unlawful. See, we don't know because the debate is still going on, and different sections of people, they are giving their own opinion, and the writer is of the opinion that when the speech, if it is confined to the matters of policy, then the governor will have to read it in its entirety. Governor cannot skip anything from that speech if it is related to the policy, regardless of what the governor thinks. Fine. But when it contains irrelevant words that would be inappropriate for him to read, and that may be against the center or that may be against the judiciary, fine, certain sort of criticism which is not healthy for a democratic state, then he or she may omit them at the risk of inviting criticism. This was the essence of this particular article. Thank you.